All rise. Division 2 of the Court of Appeals of the State of Washington is now in session. Commissioner Aurora Burse is presiding. Our first and only case on the August 27, 2025 docket is a motion for discretionary review, case number 61082-5, David Dickerson v. Darrel Voss.
Good morning, please be seated. As our bailiff announced, we are here on a motion for discretionary review in the Voss case. I am ready to hear from the moving party a few short housekeeping things before we get started. You both understand that we are now at 13 minutes per side for argument. I assume that you are the folks splitting argument. You are in charge of tracking your split time. If someone keeps talking, I'm not going to stop you. So it's up to you. With that, I'm ready to hear from the moving party.
Well, thank you, Your Honor. And my name is Chris Conley. I'm here on behalf of Darrel Voss. And beside me is Skylar Peters. We do intend to split the argument. This is Rod Harmon. Your Honor, as mentioned, we are here on a motion for discretionary review because my client moved to dismiss for two reasons at the trial court. We moved to dismiss for lack of personal jurisdiction and a failure of service process.
To clarify, we're talking about specific personal jurisdiction, not general.
Correct, Your Honor. The trial court found in its order that jurisdiction was proper and the language used was based specifically on specific jurisdiction, not general. My client lives in Taiwan, is domiciled in Taiwan, and has lived there for 5 years, so general jurisdiction is not remotely at issue. Your Honor, I intend to talk with you about two things, mainly why personal jurisdiction is not proper in this case and why service process failed. Ms. Peters is going to use the remaining amount of our time to talk to you about why that is a major due process concern. And so that is why discretionary review is necessary at this time, and we'll get into that. Very briefly, the facts of this case are fairly simple. Mr. Dickerson, the plaintiff at the trial court level, is an attorney who resides in Germany. He's a patent attorney. He practices globally. My client is an inventor of bicycle parts who 20 years ago lived in the state of Washington and started a corporation here and owns a piece of property here. But for all times relevant to this case, lived in Taiwan. From 2019 until 2023, Mr. Dickerson performed legal services specifically to Darrel Voss in his individual capacity. He wrote patents for him in his name. Those are the services at issue in this case and relevant to this motion to dismiss. Darrel Voss's corporation, USUL, is also a defendant in this case who has not moved to dismiss and is not subject of today's hearing. The point being, all of the invoices, the entire cause of action in front of you today is based entirely on Mr. Dickerson's services for Mr. Voss as an individual, okay? And so, the reason that's important is because we're talking about specific jurisdiction. And when we're talking about specific jurisdiction, we're talking about minimum contacts. And those contacts must give rise to the cause of action. The cause of action is very simple. It is an attorney-provided legal services for a client. And when those services were provided, if we give credit to the claim, which for the purposes of today's hearing we will, then an amount is due and owing. And so all you need to know is what gave rise to the cause of action that Mr. Dickerson brings to the trial court level.
I mean, I guess I'm looking also at Ford, correct?
Yes, Your Honor.
Which you're talking about give rise to, which seems to be the arise out of part of Ford. But we have the arise out of or relate to.
Yes.
And so I think we need to address both.
I agree, Your
Go
Honor.
ahead.
So the most on point and most recent Washington case that talks about that is the Downing versus Lazar case. That's 21 WinApp 2D 635. And that case goes into a very deep analysis of the Ford case. And I would suggest reading it carefully because the language used is hard to interpret. But when you read through the Ford case, and when you read through Downing's analysis of the Ford case, it identifies that the circumstances giving rise to the cause of action or related to the cause of action would not have existed except for, and that language except for, which is just another use of the word but for, is what the court relied upon in both Ford at the United States Supreme Court level and in Downing. And so when we start talking about relate to, it's not a boundless analysis. There must be a real meaningful connection between the context and the cause of action. And here that simply does not exist.
But, I mean, we do have some facts that don't necessarily weigh in your client's favor. We have work done on intellectual property with patent registrations based on a Washington address, for example. We have, in terms of the services provided here, we've got billing and whatnot all sent to this, I think, Washington PO box. So, I mean, I'm definitely following your argument, but there are other facts, and how do those not tie this back to Washington in any way?
So both of the facts that you just identified were actions of Mr. Dickerson, not actions of Mr. Voss.
I thought he said that Voss instructed him to, I mean, we're talking about doing, for example, patent applications or registrations. Did he just make up that PO box to put on there, or was he instructed to do so?
So even if Mr. Voss instructed him to do that, the fact that the patent application had the Washington address on it was an action of Mr. Dickerson, not an action of Mr.
But it
Voss.
was, these were not useful patent applications, correct? They were individual patent applications.
They were individual patent applications,
Okay.
and there were some grouped, yes.
Okay.
The point being, Your Honor, and I've only got a short moment of time here, but the point being, Your Honor, is that actions of a plaintiff cannot constitute purposeful availment for minimum contacts. And Mr. Voss, if he had told Mr. Dickerson to name an address in Australia as the place where the patent office should contact him, that still would not have given rise to the cause of action. What did give rise to the cause of action was a German patent attorney performed services for a person in Taiwan. And if that's true, which my client can test the quality and the quantity of the work, but that's not at issue today. But what is at issue is what gave rise to the cause of action, and it is that attorney-client relationship between a German patent attorney and a Taiwanese resident. And that's it. Your Honor, you can read the brief, but service of process is also at issue. The critical fact there is that Mr. Dickerson has never attempted to personally serve Mr. Voss at his residence in Taiwan. And there are means through the international process that he could do so, but he has not attempted to do so. He's been able to take discovery.
Aren't we supposed to be looking at what Mr. Dickerson knew when he commenced or tried to attempt service of process? I mean, is this an ongoing, and there were actions taken as he learned more information, but are you disputing that at the time Dickerson commenced this litigation, that he had a Washington, I think, address, I can't remember, Chehalis maybe, for Mr. Voss, and he attempted personal service there, and there were renters there, correct?
Correct. And so personal service was not effective there. That's not where Mr. Voss resided.
But that's the address that at the time Mr. Dickerson had been using for billing, for example.
Correct.
Okay.
That is that address, but that's not relevant to the service issue. Service can't just be affected anywhere that you might happen to send a bill. It must be done where, in the event of an individual.
But I'm just trying to figure out, should Mr. Dickerson have been psychic?
No, he should have simply probably had an engagement letter with his client that identified where
didn't.
Right,
They didn't.
exactly. So there were mistakes that Mr. Dickerson made.
Okay. But then, obviously he knew what he knew, and he did what he did. And at some point, he then learned about this Taiwan address, but it was long after he had done service by publication, correct?
Incorrectly, correct.
Okay.
Your Honor, I'm going to give a couple more minutes. I'll take 1 minute for rebuttal. Please
Okay.
let Ms. Dickerson argue for.
Hold on one second. Can we stop the clock, add a minute here, and then a minute for rebuttal? You can come up. I just want to make sure we're accurately tracking time here.
Take your full 3 minutes.
Good morning, Your Honor.
Good morning.
My name is Skylar Peters. The Due Process Clause of the 14th Amendment guarantees that no person may be deprived of life, liberty, or property without the due process of law. As Mr. Conley described, this case hinges on 2 constitutional due process failures, jurisdictional and procedural. Just this year, in Fold versus Palestine Liberation Organization, the United States Supreme Court reiterated its long-held opinion that a court must have power over the parties before it can resolve a case. Due process exists at the core of the court's reasoning in Fold and should be the predominant concern of this court as well. If the trial court did not have personal jurisdiction over Mr. Voss, and if service upon Mr. Voss was improper, hearing this matter on discretionary appeal is essential to avoid continued violations of Mr. Voss's due process rights. Courts must have personal jurisdiction over an individual to issue valid judgments against them. And personal jurisdiction is considered an individual liberty interest, protecting the rights of individuals to be subject only to lawful power. And because due process also requires notice reasonably calculated to apprise individuals of an action and provide them an opportunity to be heard, formal service in compliance with the law is an indispensable prerequisite subjecting any defendant to a civil action. Any judgment entered in the absence of personal jurisdiction is void. When a court proceeds against a defendant when it lacks personal jurisdiction over them, it does more than commit a procedural error. It deprives that individual of fundamental constitutional protection of which they are entitled. If litigation is allowed to proceed in this case, Mr. Voss's constitutional rights at every step of discovery, motions practice, and trial will be violated. Requiring Mr. Voss to wait until after final judgment to seek relief also does not resolve the immediate harms to Mr. Voss's constitutional guarantees. Instead, delaying review wastes judicial resources and party resources, as every minute spent in trial court, if jurisdiction is not proper, will on appeal need to be rectified.
And I assume that part of what we're talking about personal jurisdiction here and why it's so important in terms of under the constitutional framework is because you're proceeding under the obvious error prong, it requires some showing that further proceedings would be rendered useless. And here, you're saying that, for example, it would not only be rendered useless, but actually also harm your client.
Yes, Your Honor.
Go ahead.
Both under personal jurisdiction and service of process concerns, both under the 14th Amendment. An immediate review here will rightfully ensure that Mr. Voss's due process rights are preserved while also respecting the judicial resources and the broader meaning behind the constitutional protections of due process. For these reasons, this case presents precisely the circumstances that call for immediate intervention under discretionary review, and Mr. Voss respectfully requests that his motion is granted.
Thank you very much. And I'm ready for the response.
Your Honor, Rod Harmon appearing for David Dickerson, the plaintiff. Discretionary review requires an obvious error rather than just a plain old error. There's not an awful lot of guidance about what that is. As a matter of fact, I think most of the guidance is in the court's mind because this court commissioners decide those sorts of things. But this was a very fact-specific finding that this trial judge did. She kept it under advisement for several weeks, and I prepared a proposed order for her, but it wasn't anything lengthy like this with all the facts that she went through. That's probably my main reason for discretionary review at this point is a problem, but there's another reason. This was a 12B motion under which the trial court had to take the pleadings as true. It was not a motion for summary judgment in which she could rely upon the testimony of the parties. It was not a preliminary hearing under Rule 12, where there could have been an evidentiary hearing. It was not a trial where the court made findings. All of those things can happen still to develop the record for this court to review if it does take review of it, if it gets up that far. And for those reasons, I think discretionary review at this point is actually a problem. It creates a piecemeal, because if the court were to decide in the plaintiff's favor, send it back down, then we have a preliminary hearing, then we come back up, and then we have a summary judgment, then we come back up, then we have a trial, then we come back up. That doesn't make any sense. Now, I noted in the argument that we just heard that the defendant focuses on the arising from prong, and that's not really the one that we're relying on, it's relating to. I also noted that the defendant's position is that Mr. Dickerson was the one that initiated all of these intentional contacts with the state of Washington. Those are things that could come up in conflicting testimony, but it can't come up here because in the pleadings, which the court has to take as true, we stated Darrel Voss, in his applications, stated his residence was either in Vancouver or Chehalis. Darrel Voss, in his applications, confirmed that his mailing address was in Vancouver. Darrel Voss, at his direction, directed Dickerson to mail the patent certificates that he obtained for Darrel Voss to him at his post office box. Darrel Voss directed the plaintiff to send all of his invoices to his post office box in Vancouver. We're here to collect on the bills that he sent to post office box. That's why we're here. And all of those relations show an intentional placing of the business here in Washington. And you don't have to be physically in the state in order to do business in the state, particularly when we're talking about intellectual property, not a physical product anyplace. And one thing about patents, a patent, you don't make money from a patent. Having a patent makes you nothing. Licensing the patent makes you something.
I'm married to an intellectual property lawyer.
The
Full disclosure.
The only way to contact the patentee is by contacting them through the address that's in the patent that's in the state of Washington. All of those things under the Ford criteria militate in favor of personal jurisdiction in the state of Washington over this matter. Now, as far as personal service goes, we had an address in Washington.
I certainly want to hear your personal service argument. It seems like I think the parties generally agree that, for example, the Ford Motor case, it provides the most recent, probably Supreme Court guidance. There are other state cases relied on. But there really seems to be a fundamental disagreement about what relate to in Ford means. And I just want to hear your position on that. I understand it will obviously favor your client, but while we're here.
Well, let's take the Ford court's determination of it. At page 359 and 60, they said, specific jurisdiction requires an affiliation between the forum and the underlying controversy. I think we've got that here. I mean, it is very general standard. I mean, ultimately, the court said these rules derive from and reflect two sets of values: treating defendants fairly and protecting interstate federalism. Now, we don't have a conflict between states here. We don't care about Taiwan. We would care about Oregon if there were a dispute there, but we don't care about Taiwan. Fairness is the ultimate decision point here. Is it fair for this defendant to have to defend himself in the state of Washington? And, I mean, what's interesting is that he just recently came into the state of Washington and prosecuted a case to quiet title to the very property that was one of the addresses that he used in his patent application. Well, that can't be unfair for him to have to come in here and do this. Now, that
doesn't bring us into the related to. I understand you're saying the larger concept.
In the larger concept of what is fair. And that's where all of these terminologies come from, this arising from or relating to. Ultimately, we're trying to be fair to the defendant. So I guess I'd have to say for the court to consider in this case, is it obviously unfair for this defendant to be tried here? If it is, then the Court of Appeals ought to take a look at this. If it's not obvious, or if it's not unfair, then I think you ought to leave it for the trial court to finally determine it.
And you can move to the service, if you would.
Personal service. So the defendant has 3 addresses. One's in Washington, where he is the resident agent for a corporation. I mean, the agent for service of process. And that means he has to be here, physically here, so that you can go to that address and serve him. And he filed documents with the state of Washington saying that's where he was. And we were required to go there and try to serve him, and we couldn't. Tenants were there, he's not there. He lives with his wife in Portland. My client knew that, so we sent a process server down there to serve her. Served her, served him there as substitute service, but there was always the question of, well, he's not there. So now he's in Taiwan, so what do we do? Service of publication is the solution that the state of Washington's come up with. We followed very strictly the requirements that we filed, the affidavit, the declarations that had to be filed in advance.
When you started, I know it was a 6-week process, I think, the publication, at the start of that period, did you have reason to know he was in Taiwan or resided in Taiwan? And I know this is a 12B, so
Yep.
in terms of the pleadings.
This was one question that was there. Because Taiwan's a center for bicycle manufacturing,
Yeah,
being in Taiwan is a really good place for somebody to be. Does he reside there? I mean, he doesn't reside with his wife. Is there a divorce action? No. Is there a legal separation action going on somewhere else? No. Well, okay, so isn't his residence with his wife in Portland and he's just working there? I mean, people do that.
hypothetical.
Yeah.
If at the start of this lawsuit, Mr. Dickerson knew that your client actually lived, not was there on a business or main trip or something, actually lived in Taiwan and knew an address in Taiwan, then they would have had to have followed the international guidance that,
No,
Okay.
the Hague Convention doesn't apply
okay,
to Taiwan. The statute requires that you mail a copy of the summons and complaint to the person by certified mail,
okay,
if you know the address.
okay.
We didn't know the address. So so that we began the publication, we started it, but very shortly after that, we did get a communication from counsel saying, here's his residence card,
Okay.
and here's an address on the residence card. Okay? We started publication before we knew about this. I think we're safe on this, but let's send the summons and complaint off to this address. We sent it off to that address. Came back from the Taiwan post office saying that doesn't exist. Okay? We did the best we could. That's what we did. Now, there is a case that's an unpublished case out of Division 3, the Bland case, I think it was, where there was a defendant in Canada. And that court said, well, heck, that's only like 20 miles away from where the plaintiff was. You should have gone over
Practically
there.
another state.
Pardon me?
I said it's practically another state.
Exactly.
That was a joke.
According to some.
Go ahead.
According to some. They made it an unpublished case, which I thought was an interesting decision on their part. I don't see any kind of published authority that says, look, you've got to go into another country and track the person down, hire private detectives or whatever. And when I consider the condition of some of the other countries in the world, that seems to me to be a pretty fair rule. Particularly in this case, because, obviously the defendant came in. I mean, he was quite aware of it because his company was served here, through his wife, who was an officer. He's quite aware of it. From a fairness point of view, I don't think there's any justification for the court to have said it'd be unfair, the trial court, it would be unfair to have this guy trialed right here. That's the end of my argument.
Thank you.
Your Honor, I think I have about 1 minute.
And I'll let you talk. Go ahead.
All right, thank you, Your Honor. With regard to personal jurisdiction, there's a critical question that should be asked with regard to every fact that Mr. Harmon or even the trial court suggest led to or relates to this cause of action. And it's if you took that fact away, Mr. Harmon's client's claim would still exist. If Mr. Harmon, or I'm sorry, not Mr. Harmon, if Mr. Dickerson never listed Mr. Voss's Washington address on a patent application, but put it elsewhere, the cause of action would still exist. If USUL, the entity, ceased to exist, the cause of action would still exist because those patents could be licensed elsewhere. And so personal jurisdiction simply does not exist in Washington because this cause of action does not arise from one single contact or even relate to one single contact with the state of Washington.
Doesn't
And that
relate to bills sent for Washington for services that
Miss-
were never paid?
Mr. Harmon could have sent, excuse me.
Go ahead, no, finish.
Mr. Harmon could have sent his bills anywhere. He would still have the same cause of action. He also emailed his bills to my client, which were received in Taiwan, where he knew his client resided. It is not unfair to have a patent attorney who chose to represent someone in Taiwan have to collect on his bills there.
Thank you.
Can I make one more point on personal service?
Quickly.
Okay, Your Honor, one thing that Mr. Harmon clearly said is that when they determined that Mr. Voss lives in Taiwan, they went straight to service by publication. And the Rodriguez case and the Bland case both say it is a requirement before you can use service by publication to attempt personal service, and there is a process in Taiwan for that. It's not the Hague Convention, but there is a process.
Okay, thank you. I'd like to thank both parties for their argument today. Excuse me, I just want to write down one thing before I forget it. I'm going to take this matter under consideration and issue a written ruling on the motion for discretionary review because this is a matter that is still pending in the Superior Court. I generally do ask parties who are before me on discretionary review whether there is any important Superior Court setting that is imminent that you want me to know about. I'm getting no.
Not in the immediate future.
Trial is in February.
Yeah, trial dates, for example, are important for me to know about.
Of course.
Okay, thank you. I would also like to thank our fairly recently admitted attorney for arguing today. We do encourage that, and we do like to give younger attorneys appellate experience. So thank you very much. And with that, we will be adjourned for our morning calendar.
All rise. Court is now adjourned.